We have a third generation C Corp that won a 25-year lawsuit. So I'm going to assume that's a lot of money. That judgment is considered income. Great observation, by the way. Whenever you get a judgment, typically that is income and thus subject to income tax. Now, the only time it wouldn't be is if it is compensation for harm, and that then gets into certain tax rules and how that was reported to the IRS in prior years. But I'm just going to take as true the assumption that in this scenario, the judgment is going to be large and subject to income tax. I'll proceed with the question. We no longer want to continue with the business and what we've done in the past. Company has a lot of income coming in from the judgment. Would you advise us to let the C Corp be a holding company and make any new investment in an LLC under it, or switch to an S Corp? The first question in the analysis is, should you have a new company or keep using your existing company? The second question is, should that new company be a C Corp or not? And the third question is, should the new company be an S Corp or LLC? So first, should you set up a new company? You may not be able to. Here's why. If the money is coming in to an existing company, that company is the one that will have to receive the check. And if that company has creditors out there that it owes money to, then some of that money will have to be paid out there. You can't just move all of the money to a separate LLC and have it be protected from creditors of the original company. You also cannot just have the lawsuit money paid to a separate company. It needs to be generally paid to the company that won the lawsuit. But let's say you don't have any creditors. Then what do you do with that money? At that point, I would work with a CPA to think through, are there any tax consequences to what you're weighing here, and make sure whatever you do is with knowledge of any tax consequences. Usually what happens is the money from the company is distributed to the shareholders, and then the shareholders can do whatever they want with that money, like investing it on their own. But let's say for some reason you don't want to distribute the money from the corporation to its shareholders. Then what do you do? Well, if the corporation is concerned that it might have some liability later that could put that money at risk, like let's say a customer could come from 3 years later and sue the company. The corporation may not want to have that money sitting there exposed to creditors who would come down the road. What you may want to do then is transfer the money to a separate business. There are going to be what's called look-back periods. That means if you transfer the money and a creditor sues the original company, the creditor might be able to have the court pull that money back, which is called disgorgement. Disgorgement is when the judge orders money to be disgorged from the old company and transferred back to the original company so that it is available to be paid to the creditors. And that period of time in which disgorgement can occur is called a look-back period. It's the period of time in which a judge can look back and say, hey, do I want to undo a transaction? But you might as well get the money into the new company and work with an attorney on this so that it's done right, so that hopefully the look-back period passes before some new creditor comes along and makes a claim, and then you now have that large amount of money exposed. Now the question then is, should that entity be an LLC, S Corp, or C Corp? Usually you don't pick C Corp because it gets double taxation. You're probably going to have it be an S Corp or an LLC. If the entity is owned by individuals, then you would probably have it be an S Corp, but that should be a decision made by the CPA. That's so that you can reduce payroll tax or self-employment tax. If the entity is going to be owned by another business it may need to be an LLC because as a general rule, S corporations need to be owned by individuals, not businesses. In that case, let's say you had that LLC holding all of the assets and it is owned by a company. The LLC then would pay the profits to the company, and then ultimately it would come to you. It's very possible it would be subject to 15% self-employment tax. Bottom line though, this gets complex when you're dealing with multiple entities. It also matters how those entities are taxed, and a CPA is best equipped to help you figure out the structure that will minimize taxes for you in a way that's defensible with the IRS. There might be some judgment calls here, and if a CPA has a judgment call, the CPA might say, hey, you can do this option, but it's more risky and saves more money on taxes, or you can do this option. By working with a CPA and relying on the advice of a CPA, usually you have some protection under the law, because one of the defenses for tax fraud is you relied on the advice of a licensed professional. So I don't recommend doing this stuff yourself, and certainly don't make these big decisions based on what you hear me talking about here. The reason I'm explaining all this today is so you can get a framework for how these decisions are made and identify what topics to bring up with the professionals that you work with. I would work with a licensed CPA who deals with small business owners. Ask that CPA to put together a plan for you. By the way, it's not going to cost that much to get some recommendations from a CPA. I would think for less than $1,000 in CPA hourly time, you would have 1 or 2 meetings with a CPA, and the CPA could come up with a very specific plan for how to do this. The cost to implement it might be a couple $1,000s more, but that is minimal compared to the risk of doing things wrong and either having a huge tax bill or liability for tax fraud or not paying the proper tax amount. All right. If you would like to get notified about the next live session, you are welcome to subscribe to the Aaron Hall Attorney YouTube channel. You are welcome to subscribe to our little reminder email system at aaronhall.com/free. You can also sign up and follow us on other social media sites. I'm Aaron Hall, an attorney for business owners and entrepreneurial companies. It was a pleasure talking with you today and answering your questions from an educational perspective. As I always say, before you rely on any of this, consult with an attorney. It's my hope that you use these questions to identify topics and questions to bring up with your attorney. Until the next live session, I hope you are doing well. Take care.